Hello landlords, it's Ernie. I'm back, and today we're talking about our least favorite landlord, the know-it-all. Let's get started. I am in the middle of a series that I'm calling Landlord Lessons based on experiences that I've had in the court over the last 11 years. I hope you watch every single one of these because they will all be helpful. So when I'm thinking back on the kinds of situations that I've seen, there's almost nothing worse than a landlord who interjects in an eviction proceeding beyond what is absolutely needed. I always give the following advice to not just landlords, but every client that I represent in a trial or a deposition. I tell them the same thing. I say your best answer is your shortest answer. If you can answer in one word, do that, and whatever you do, don't add information that was not otherwise asked of in your question. So many times we want to embellish or we want to explain a certain answer because we have so much information to give, but that's where we get ourselves in trouble, just like the landlord in today's story. So let me set the picture for you. I was representing the tenant, who in this case used to be the owner of the property. She had lost the title in a foreclosure because she had gotten behind on her mortgage, and so now she was in the middle of an eviction proceeding, and the attorney for the other side and I had attempted to work things out, but his client simply wouldn't budge. So we had lost the case on the JP level, and now we found ourselves at the county court, and we were presenting our case for the second time, and I was presenting the same defense that I had presented the first time and had found unsuccessful. And it had to do only with the notice to vacate. I believed there was a defect in it because of the language that the counsel for the owner had used. I believe that it created an ambiguity that allowed my client additional time. The Justice Court disagreed with me, but I thought, why not present the same argument to the county court? Now, the owner who attended the first trial and who had been successful there thought that I had a terrible tenant and a terrible argument. In fact, while we were outside prior to the trial, I do this all the time, was simply saying hi to the opposing counsel and letting him know that my tenant had arrived and that we'd be stepping inside the courtroom. I usually make a little small talk with opposing counsel, but the owner was there, and he made it a point to tell me that it was ridiculous that we were there in the first place, and along with it being a waste of time, I was doing a bad job representing someone who was not entitled to a defense. Well, that's fine. You can have that opinion, but everybody's entitled to a defense. And so I think that mindset was the landlord's first error. So we go into the courtroom and we begin the case, and naturally, because I'm representing the defendant, I go second. And so the plaintiff presents their case. The cause of action is based on a foreclosure, and the notice to vacate was sent after the foreclosure was completed and my client failed to vacate. Pretty easy. There's no rent issue for the court to resolve. It really comes down to whether or not the plaintiff has a superior right to possession over the defendant, who was my client. So I proceeded to present my evidence of the defects with the notice to vacate. Again, I don't have any evidence to controvert the foreclosure. That just didn't exist. So while the plaintiff's attorney presented the entire case for the plaintiff, the owner decided he would interject when it came to cross-examining the defense's evidence and our argument against the notice to vacate. And he gave three statements to the court. the three statements that I think ruined his case. We welcome your questions and comments, as always, to this video. What is it that you liked about it? Is there anything in particular that caught your attention? Tell me in the comments below what you think about today's video. So the first thing this landlord wanted to tell the judge, I guess to impress her, was the following, quote, "I've been in real estate investment for 30 years. And then he proceeded to tell me how my argument regarding the notice to vacate was totally wrong, again, based on his experience as a real estate investor over the course of 30 years, which really has nothing to do with the status of the Texas Property Code or its requirements. But somehow he believed that this statement added some kind of, bona fides, I guess, to his argument or his response. It didn't. Nobody found that impressive, and it didn't persuade the judge in any way. She continued to hear my argument and what I had to say about a particular clause in the notice, which I believed was misleading. So we're going back and forth, and he comes back and he says, "Look, frankly, Judge, I think you are, quote, misunderstanding the facts." Now, he said this probably because the judge continued to ask questions about the meaning of this clause in the notice to vacate that was sent to my client. I'll tell you that it wasn't a standard notice to vacate. I don't believe this particular attorney did much eviction work. It seemed more like he was in the process of debt collection. And perhaps this was one of the functions that he served for this particular client in the past, that he collected certain debts on his behalf, because the language in the notice to vacate sounded very much like the kind of letter you might get which comports with a provision in the FDCPA or the Texas Debt Collection Act, and not so much Chapter 24 of the Texas Property Code. Now, I recognize this in the letter, and in those letters, there's always a provision, or generally, a provision that requests of the person receiving the letter, if they have any questions or if they contest the validity of the claims in that letter, that they have 30 days to write to the party who's making the claim, and that the party will reach out to them in hopes of resolving whatever the complication is. Now, I argue that that statement alone didn't make for an absolute demand for possession, right? Which is what a notice to vacate should be. An absolute, unconditional demand for the tenant to get out. Not, well, you have 30 days to ask questions and we'll get back to you and talk about this. So based on that, I made the argument that the notice was insufficient as a notice to vacate, and the court was entertaining this argument. But again, the owner, not counsel, but the owner had taken over the proceeding and said one final thing. "Well, I just don't agree with the way you're taking this case." Not to me. He said it to the judge. And that's when she got really mad. She said, "Look, you really should let your attorney speak, because I'm the one who makes the decision. In fact, I'm done," is what she said. She turned to me and said, "What is it that your client is asking for?" And I said, "Your Honor, we're asking for attorney fees and for a judgment in favor of the defendant." She said, "So granted." She banged her gavel, and it was over. I submitted my order to the court. They signed it. So not only did he fail to get an eviction, he now owed my client all of her attorney's fees from the first proceeding and the second proceeding. So what am I saying? Am I saying that landlords should never participate? No, I'm not saying that at all. I'm saying it's a very good thing for landlords to participate. But landlords, if you are stepping over your own attorney, if you are presenting more evidence than is needed, and definitely if you are condescending in any way to the judge, you can just expect things to go terribly wrong for you. You may disagree, but I don't know how many times I've had to tell my clients, stop talking. I literally whisper in their ear, just wait. And for the clients who have listened, that advice usually helps. It usually works to keep them from going just too far with the judge or saying just too much, right? But for those landlords who have not heeded that advice, sometimes you have a winning case that is sunk by the things that you say. Your landlord lesson today is, number one, listen to your attorney. If you and your attorney have a course of action, let the attorney follow it through. You can answer the kinds of questions that the attorney makes to you, but again, limit your answer. You know, brevity is the soul of wit. Keep your answers short. If you can answer with a yes or a no, leave it at that. No need to add anything. Second, if you disagree with the judge, don't tell the judge. This is something that I fell prey to early on in my career. If I disagreed with the judge, I let the judge know. Your Honor, I think the property code says X, Y, and Z. Not once did I convince a judge. Not once did I convince a judge that they were wrong. Even if they realized they were wrong, not once did a judge ever reverse him or herself because I shared wisdom that they lacked prior to their ruling. So you always have the opportunity to appeal. You have motions you can file to undo, errors in the law, but don't ever try to correct a judge. It's just not going to work. Finally, if you're failing to follow the law, the fact that you have failed to do it right numerous times in the past does not make it in and of itself correct. I don't know how many times I've had landlords tell me, but that's the way I've delivered notice forever, and it's never been a problem. Again, that's just not true. The fact that you haven't been caught doesn't mean that you were doing it right in the first place. You should always be prepared, if you have failed to follow the law, for the law to go against you. And if it turns out that the court catches you on some error, just be prepared to represent your case either with a new filing or to present a different argument that is just as good. Leave that other argument out, especially if you know there's a defect in it. From time to time, I have clients come to the office and they have a defect in their notice or they have a defect in their pleadings, and I tell them outright, I don't believe you can be successful in the court. And they disagree and they proceed and then they lose, and then they come to me and say, all right, I need help. Can you help me? And so if you can avoid that kind of waste, just do it. If you have a problem, again, just because you've done it wrong time and time again doesn't mean that the court is going to find that in any way persuasive. So I hope you have enjoyed today's video, and I hope you've learned a little bit about the know-it-all landlord and how that know-it-all gets himself in trouble so often. If you can avoid it at all costs, avoid being that guy. If you enjoyed today's video, please do not hesitate to give us a like. If you haven't subscribed yet, you're going to find a picture with my face on it. Click on that and you can subscribe. There's also a video here that YouTube seems to think you will enjoy. Please click there, enjoy that video, and until next time, landlords, happy leasing.